Hello again, I'm TODD YEARY, and welcome to this week's edition of Due Process. The efforts to advance police reform after the death of George Floyd and numerous other in-custody deaths failed, as no agreement could be reached between Democratic and Republican negotiators led by Senator Cory Booker, Democrat of New Jersey, and Senator Tim Scott, Republican of South Carolina. Even with significant concessions such as the removal of qualified immunity, the criminalization of excessive use of force, and no-knock warrants from the proposal, Senate Republicans would not sign on to the bill. Some have even criticized Republican positions that opposed pieces of the proposal that had been supported in previous versions. In what appears to be a clear moving of the goalposts to avoid reaching consensus, not even support from the Fraternal Order of Police could motivate an agreement around the other parts of the bill. Senator Scott accused the Democrats of walking away from negotiations and squandering an opportunity to implement meaningful reform. While the finger-pointing continues, the state of policing, after the murders of George Floyd, Breonna Taylor, Philando Castile, Corinne Gaines, Freddie Gray, Dante Wright, Andre Hill, Manuel Ellis, Rayshard Brooks, Daniel Prude, Tatiana Jefferson, Stephon Clark, and many, many others continue to highlight the sense of urgency that is missing from these negotiations. As Reverend Jackson, I, and the Rainbow Push Coalition wrote in our submission to the United Nations High Commission for Human Rights, the United States continues to be in violation of its obligations under the International Convention on the Elimination of All Forms of Racial Discrimination. Specifically, portions of Article 2, which require that the United States, quote, take effective measures to review governmental, national, and local policies and to amend, rescind, or nullify any laws and regulations which have the effect of creating or perpetuating racial discrimination wherever it exists, and shall prohibit and bring to an end, by all appropriate means, including legislation as required by circumstances, racial discrimination by any persons, group, or organization, end quote. Until these fundamental human rights are protected, we will continue to demand action from the Congress and the courts to ensure adherence to the treaty obligations accepted by the United States when it ratified the convention in 1994. Immigration issues continue to dominate the news as thousands of migrants seeking refuge are massing at the southern border with Texas. While most of these refugees are reported to be Haitian, there are many from Central American countries also seeking refuge. The outcry against mass deportations of Haitian refugees continues to highlight the disparity in treatment of refugees and asylees of color. As we have seen under the Trump administration, which rescinded many of the visa provisions and temporary protected status for migrants fleeing political oppression, the treatment of Haitian immigrants seems to contradict the assertions of the Biden administration to promote a more humanitarian immigration policy. While the Biden administration has indicated an intent to raise the refugee cap to 125,000 in fiscal year 2022, there has been no specific indication of which refugee challenges will take priority, except as it relates to Afghan refugees seeking admission after the end of the war in Afghanistan last month. Based on the administration's commitment to resettle 62,500 refugees by September 30th, the end of the current fiscal year, only about 8,000 had been resettled by the end of August. This would indicate more than adequate capacity to reconsider the current policy of deportation and, in some instances, violent and aggressive acts against Haitian refugees, as seen in some of the images from the southern border. This week, we saw action in federal courts around immigration policies. Because most of the migrants at the southern border have passed through another country, the restriction on asylum applications for persons who have entered another country prior to reaching the United States continues to be a relevant issue. Immigration advocates have asked the D.C. Circuit Court to leave a ban in place for the policy that required asylum seekers to first apply for asylum in a country they have entered prior to reaching the United States. Even though the interim rules for the policy that prohibited asylum applications without adhering to this requirement have expired, there is a concern that the courts must weigh in on the propriety of imposing such a requirement without first receiving public comment. The Biden administration is asking that the lawsuit simply go away because there is no longer an issue. Advocates want the courts to settle the legal question in the event that this administration or any other might try to circumvent the public disclosure process to advance a discriminatory immigration policy. Also, in Florida, a federal judge struck down portions of a 2019 state law banning sanctuary immigration policies as unconstitutional because the law demonstrated a discriminatory intent and violated the Equal Protection Clause of the 14th Amendment. The court found that the city of South Miami and immigration organizations had demonstrated that racial discrimination was a key factor in the passage of the state law based on involvement of anti-immigration hate groups in drafting of the legislation. Additionally, the local governments and advocacy groups argued that the law led to increased racial profiling, harassment, and detention of people of color, and undermined trust in law enforcement due to a climate of fear and intimidation. As a result, the judge barred the state from enforcing provisions that required law enforcement agencies to cooperate with federal immigration enforcement efforts, and also barred state limitations on local governments from adopting sanctuary policies that would prohibit such cooperation. Rainbow Push Coalition and our partner human rights organizations will continue to monitor the refugee situation on the border and continue to press the Biden administration to honor its commitment to a more humane and responsive immigration policy. Finally, last month, Ancestry.com released what has been called the largest digital collection in the world of searchable records from the Freedmen's Bureau. The collection of more than 3.5 million family and bank records is being made available to assist descendants of formerly enslaved persons in finding out more about family lineages. The Freedmen's Bureau was created and established after the Civil War to assist formerly enslaved persons in their transition to freedom. The records in the database include labor contracts, marriage records, personal letters, and other documents. While public awareness of the Freedmen's Bureau has historically been very low, the availability of the database could prove very helpful in deepening the knowledge about families and relatives that many thought would not be possible. Here's to good researching. And that is this week's Due Process. For more information on these issues and other areas of our work, visit rainbowpush.org. I'm TODD YEARY.